Hi, everybody. Welcome to our USCIS EB-5 Stakeholder Engagement Call Review and Analysis. We wanted to do a live event with the Behring team. I'm joined with my colleagues, Greg Sheehan, our director of the EB-5 platform and USCIS compliance, a licensed immigration attorney, as well as a former USCIS adjudicator, as well as Peter Bibler, our managing director. And today we are going to review everything that we just learned from USCIS about the couple of topics that were mentioned in the agendas, and then the things that we learned, and also some things that we didn't learn. So we're going to go through this rather quickly because we want to get to a Q&A session at the very end of this, where everybody that is here can actually use the chat feature to log questions and to be able to ask any questions that might be on your mind, things that went unanswered by USCIS, or anything that happens to be on there. But we'll talk about a general summary, the main topics that were listed, the 956K, as well as items that were supposed to be about the sustainment period, and then reading the USCIS tea leaves. They gave us some nuggets on some information and things where we have to kind of read between the lines to see what's going on, and we'll discuss those things as well. Again, the chat feature is open. People can ask questions and go ahead and fire away with whatever you'd like to know. As I mentioned, Peter and Greg are here with me today. Aaron and Kyle are working and moderating on the questions and lining things up, but you had the full team here intact. So the item that seemed to get the most attention, Peter and Greg, the 956K. If you guys just want to take it away and kind of discuss what we were expecting on this call, as well as kind of what did we actually learn.
Well, either one. I think the when we got the announcement, and this was a rescheduled call. This call was supposed to happen back in March. Yeah. It was bumped to today, covering three topics. One, the I956K form, which is for agents and promoters of projects, EB-5 projects, and we'll talk about the breakdown of that, as well as questions about the investment period, or sometimes referred to as a sustainment period, and then the question about what happens to regional centers that are winding down and leaving the EB-5 program with no new projects. And today was really the I956K show. So USCIS really did not talk about the other items and kind of punted that. So we'll walk you through about what this is. Now, for those who don't know, the I956K form was recently published, went through a notice and comment period, but it is for direct and third-party promoters and migration agents. So these are mostly overseas agents and immigration consultants. They need to register now with USCIS. This is brand new since the passage of the Reform and Integrity Act last year. And there are a lot of questions surrounding this as to who must file, when they must file, what must be included. And I think Greg and I and Colin will kind of walk you through as to what's required and why this is important.
Yeah, one of the things that I want to circle back on is that the last element of what happens with previously approved regional centers, like you said, they punted the issue, but I think that the uncertainty from those regional centers considering whether to move forward is related to what they're going to do about the agents that they use overseas. And I think that a lot of questions coming up are from active users of EB-5 and post-RIA, but also those from pre-RIA considering whether or not to move forward.
Yeah, I think the issue here is really the goal, and this is the good thing about the I956K, is that the purpose of the RIA, the Reform and Integrity Act, is for greater integrity to the program and more transparency to the program. So the goal of the I956 is laudable. All persons that are promoting EB-5 need to register with USCIS. What happens from there is a mystery. And that was clear from today. But regional centers, issuers of securities, agents, broker dealers, all persons that are involved in working with an investor and promoting a project or working with an investor on choosing a project need to register with USCIS. They need to disclose any fees that they may be getting. They need to provide the written agreements that they may be that govern these documents. And it's a relatively straightforward form. What we don't know, and these are some of the issues that comes next, is will there be a public database of registered promoters in the future? USCIS said today that they're considering this option, but there's a lot on their plate right now to implementing the Reform and Integrity Act, so we don't know how long this will take. There are similar programs overseas, like the Australian immigration programs have a registered public database, searchable. You can look for registered agents, migration agents and such, for example, and I'm hoping maybe we're going towards that in the future, but I think that's far out. My biggest concern is that USCIS now will be inundated with thousands of forms, and these will be duplicative. And Greg, you can probably, since you were recently at IPO, you can kind of testify to this a little bit more. There's probably 90 staffers in the IPO office in various capacities. I'm just basing this on the recent GAO report. Yep. And I'm just worried that this will divert resources or provide a distraction away from the biggest issue that's facing investors, which is processing times.
Yeah, my view on the way that the data is going to be used is that at some point this will be digitized, perhaps not in the short term, but digitization gives fraud detection, national security, and other investigative components who are going to be using the Integrity Fund to go overseas and do their investigative work per the RIA. I think that's what the RIA wants. I think that's the way they want the data used in an efficient way. Obviously, the math is going to push into digitization as opposed to using human resources, because like you said, there's a lot of forms, a lot of data. You need to be able to identify what data is meaningful and whether or not to act on it, instead of just picking and choosing, trying to find a needle in a haystack.
Yeah, and then Greg, I know we had some conversations previously, and especially looking at the other listening call, if we had reviewed, and USCIS actually gave us some insights as to how many people were still at the IPO office, how many adjudicators they had. They're right now inviting thousands of new petitions and entities and people to file this 956K. You need to file any changes to it, any amendments, anything and everything that happens to it. If USCIS wasn't busy before, they're going to be incredibly busy now, not approving petitions the way that we all hope they would, because who's available to go through all of these things as fast as what the RIA policy says they're supposed to, when they have I-526 targets of 90 days. And then the 829, I believe, is it 240 days? I can't remember the exact number, but they're inviting a lot of data and agreements and forms with this new 956K, and it'll be interesting to see what those impacts are. But they're also collecting a lot more fees, and we can talk about that a little bit later on.
Yeah, it's really a question of what they're going to do with it and when, what triggers it, what triggers further review, whether or not they're collecting forms or actually going through it. Are they getting it into systems in an electronic way with scanning that's already potentially in place in the near future? So it's a good question. I don't think we're going to see the many officers coming off adjudications to work on this. I think you might see people that are pre-adjudication in the hierarchy be assigned to this type of work. Okay.
No, that would make a lot of sense. And, to kind of have everyone specialize, and the people that are trained up on adjudications to just kind of keep rolling in that direction. And then with all the talk of AI and the ability to scan data quickly and all those kind of things, for the government to have all of this digitized and at their fingertips, and someday be able to mine it efficiently, it would be interesting to see how much more efficient this process becomes. And I was pleasantly surprised to hear that, Ellis filings, that kind of thing, was going to continue now. We've said it multiple times on our previous events, how it was, just kind of ridiculous that they abandoned the electronic filing capability years back and tried. But now it looks like, they have now, kind of hit rock bottom and they have to. So, having these electronic filings, do we know when we're going to get guidance on how that's going to play out, or like the immigration attorneys? I don't know if you've heard anything on your committees or anything of, when that's supposed to start taking over.
Ellis and digitization have probably different timelines. I'm not sure. I know that Ellis and better systems integration is something that we've been working on for a while when we were at the office, to be able to streamline productivity, because it's not just a matter of decision making, it's actually processing too, that needs to move from paper into digital art forms, right? So TBD, there's always going to be setbacks. And like we saw just with an engagement meeting that was scheduled for a month ago, that got pushed back. Our own filing dates are getting pushed back. It's tough to predict with IPO.
Yeah, understood. I wonder, is anything else that, or we can kind of move through this a little bit quickly. Back to the 956K, how much of a problem do you guys see how deep USCIS is wanting to see with these promoters, their sub-promoters, their employees, everybody really needing to sign on and register with USCIS? What do you think the outcome of something like that is? Whether groups that use agents, people that rely on agents, even reading the questions that came from USCIS, they kind of seemed like, it's mandatory for this process to get worked out. It sounds like it's going to move the needle here with a couple of groups.
Well, I think one of the things that regional centers that rely heavily on agents will need to watch out for is agent compliance. The one of the main questions that came up today was, will a regional center, and more importantly, will an investor's I956 petition or 829 petition be impacted by a third-party promoter's fraud or misrepresentation with respect to this form? And USCIS did not give a clear answer. They said yes if, no but, depending on if you want the long form or the short form. And that basically said, they're mindful of the fact that there are innocent investors out there, of course, that are not party to misrepresentation on a form, but they leave open the possibility that an investor could be impacted by third-party non-compliance, and the regional center could be impacted by a third-party non-compliance. And that really puts the onus on the regional centers to make sure that their own internal processes and oversight of their partners is in place. And that's something that is actually required by the Reform and Integrity Act. And I think USCIS was reiterating that today. But it shows that you can't cut corners in this process. And that's why you need disclosures, and it's good to choose regional center platforms that are not trying to cut corners and making sure that everything is fully on board.
Yeah, I think to some extent this exercise is going to act like as a deterrent for the reasons that you mentioned, but it's also going to bring some corner cutting attempts, right, from regional center operators. And, investors need to stay clear of that type of business.
Yeah, and we've seen issues out there where people are trying to find out, how can you cut corners? How can you kind of circumvent, the need to file and to register and to do all these things? Agents, have asked us, point blank, can we just not sign the form and not say anything? And USCIS made it clear that, repeat offenders, could be sanctioned and or permanently banned from the EB-5 industry. And they're going to be collecting a lot of documents. So it's going to be interesting to see how that plays out and what kind of effect it has. But they also, as Peter mentioned, there could be collateral damage where investors that go through these parties, if there's nefarious activity that's going on with those groups that don't handle their business, you theoretically could be terminated, and your petition denied. They left a disclaimer that they're going to try and make some game time decisions once they see the facts and who's involved and how much, but they definitely did not give a blanket, a blanket protection for the investor compared to which agent they choose or which platform they choose. And if you're dealing with an EB-5 platform that has a lot of history working in those gray areas and paying people under the table, you theoretically could be at risk of their activities of life's prior past. So interesting to see USCIS really coming after that. But we can probably, anything else on the topic?
Well, I do want to maybe just, I don't want to scare people and think, like that the industry is rife with fraud and misrepresentation. It's just, and I know that, we have a video on this where there was a GAO report recently on and analyzing these issues in the EB-5 industry from, I think, 2016 to 2021 was the study period. And there was a video on that, so we can probably put that in the chat for people to watch. And we'll do another video here shortly too, just kind of on this, maybe a short form session analysis of that report for people to follow along. But obviously transparency and integrity is very important, and it's there. It's certainly much better under this new regime.
Guys, got an important question here from Kishore. He had asked, what is causing all of these changes and all of these policy items at USCIS? Like, is this a response to macroeconomic conditions, geopolitics, or what is it? Why is USCIS doing this? Just open opinions, guys.
Yeah, I think it ties. I was going to say it ties directly into this issue. As we've seen, the agents overseas are not regulated, and now they are, and it's that simple. They need to be. I think that it's a response to investors who have felt like they haven't been given adequate representation and connection with the project itself. We've heard the horror stories of people who have been contacted by agents who might even use less than ethical means of trying to get people to sign up. They send the money over to the United States. There's a problem. They can't get in touch with the project. They can't get in touch with the agent. This happens, and it's happened too much. And Congress is aware of that. And it's separate from fraud, which the GAO investigated, which is limited to what you see within the side of the scope of the adjudication in front of you. That does not involve agents. So when you see this broadening of the applicability of Congress being able to make sure that the executive branch does its job, I think it's a reaction to a market condition that has been harmful for investors. Yep.
Peter, any thoughts?
Yeah, I just wanted to clarify, USCIS is not a political body, and the IPO doesn't have a political agenda. It's just doing its best within the parameters that it operates to implement the Reform and Integrity Act. So the politics, any political situations that are driving this would come from Congress, and in terms of and the parties behind that, stakeholders in the industry that were driving the Reform and Integrity Act, and there you have a perception of historically of problems with or dissatisfaction with aspects of the regional center program in EB-5 historically, and some factions on whether we should be emphasizing rural development versus urban development, whether or not there's actually national security concerns from investors coming in, who are the investors, and a lot of that is actually just shows that there's a need for Congress to be educated on the day-to-day realities in the EB-5 program. I think sometimes the politics gets a little too much, and they kind of lose sight of the fact that these are for the most part, or for the 99% hardworking families looking for opportunity and willing to provide investments in the United States that actually create full-time American jobs. And that's pure and simple what it is, a job creation program, pure and simple, and tax-free to the U.S. Taxpayer. And we shouldn't lose sight of that, the value to that. And I think that the politics is not from USCIS or the IPO. It's politics comes from, at the congressional side.
Yeah,
I would agree with that. I've worked at USCIS under different administrations, and I've seen politics come in, especially with humanitarian events and targeting certain nationalities from entry. And IPO has overall been kind of in the middle. People have loved it or hated it for different reasons, but it's never swayed with every 2 years or every 4 years.
Yeah. And as far as, looking at, what's causing these regulations to come out and like, why did USCIS start focusing on this and everything? It is all about integrity, compliance, and being able to increase the quality of the program. And whether that's for Congress or whether it's for just economic growth and impact and wanting to protect the program, it's definitely in reaction to really items that are historical from way years past. This is a long time coming. This is not new. This is not something that was like, hey, there's an item of fraud here, and then like 2 weeks later we get policy. When you see things in the news, items, projects that fail or fraud or some sort of misuse of funds, it probably has already passed through what you'd guess to be almost 5 to 7 years of propagating. The fraud happened, the projects went bad, there's misuse of funds, it goes through an investigation, then all of a sudden it hits the news articles, and then there's finally some sort of legal decision that makes it final, and you get a final news like write up on it where all of a sudden it hits the public airwaves. Like, it takes absolute years. So when we look at the GAO report, or GAO, the GAO report gave us definitive numbers on how much is involved in fraud and national security, and it was minuscule, less than 1% of any of the petitions. I believe it was 2017 to 19, or there was a very finite period where they found like the statistics for fraud, less than 1%. National security, Peter, I think you had it at 0.3% were national security issues. So the agent items is definitely trying to clean up the way that projects are promoted. So people that are promoting, people that are steering life-changing decisions for an investor, those people need to act with integrity. If they need to report and openly be transparent about how much money they're being paid to say what they're saying, it might tell you a lot about the quality of advice that they're giving people. So if these agreements and these numbers and these are all this activity is actually put out in the open, which is what's required by the 956K, integrity will increase. So the other issue is that typically finders agreements and or agents plus any sort of commissions, they're typically upfront paid compensation. If a upfront compensation is paid before any other performance of the investment is actually taking place, that person is heavily motivated to say anything to get somebody to jump into an investment, close, get paid, and then their job is done. That is not the highest level of environment for integrity. So 956K will address some of those issues. The transparency will definitely help the investor, because most of the EB-5 investors or all of them should be a certain level of sophistication. If you see an agent that's making X compensation to feed you information, you can determine what levels of information you want to give respect to and or base your decisions on. So ultimately, 956K is totally purposed with just increasing integrity in general. And there's not really one single trigger, whether it's political or economic. It's definitely not economic. USCIS is not looking at economics and making policy decisions. It's just way too slow. So you couldn't look at any sort of economic change over the last year, 2 years, COVID, anything in the middle. It's absolutely not economic. It would really be about administering the program in integrity. That would be my thoughts. As far as going back to where we were at here, Peter, you had some notes here on the I956E and 829 issues. We did learn a little bit about what USCIS was thinking here and how they want to react to certain questions.
Yeah, I mean, some of these were investor-driven questions to USCIS, and for our viewers too. If you go on the USCIS public engagement site, you're going to see future public engagements posted, and anybody can participate. So if you do want direct participation in these, you have it. You have the opportunity for it. So just go to the website. We can share that with you, and you can register for these events. But and ask questions. Sometimes your questions don't get answered, but that's a separate issue. But we did learn a few things. One, from practical speak, in terms of practical filings for the I956, we already knew this, but you don't need to file the project-related documents with your 526 petition. These petitions post RIA are much simpler now and easier and faster to file, because the projects will have already filed a project exemplar form with USCIS. Biometrics are no longer required as of September 2022. So if you do have pending petition or pending biometric applications, you're going to get refunds. But they can still, on a discretionary basis, ask you for that. They talked a little bit about concurrent filing and fees. And again, for folks, if you're not familiar, concurrent filing is a new feature under the law that allows you, if you are in a valid visa in the United States already, to file your I-45 adjustment of status application and along with your EB-5 I-526E petition. And this is a fantastic feature to the EB-5 program. It's long overdue. We're still waiting to get some kind of advanced parole for overseas investors. That's far overdue. But basically it means that if you're in the US, you file, you're going to be able to get an EAD card or a work authorization in about 3 months. And the advanced parole does come separately. And just today, we got notified by one of our investors, one of the first investors who filed after our successful lawsuit last year, that they just got their advanced parole today. So that took about 8 months on average. So that was good news, and it's good to see, get a concrete idea of when these are coming through. The 829s, investors were asking about when they can file. Again, it's that 90-day period after you've had the green card for 2 years. So right before that, when you get a conditional green card, it's valid for 2 years. 90 days before that expiration, that window is when you can file your I-829 petition. And USCIS today confirmed that your conditional green card will be automatically extended for 48 months while you're waiting for the 829 petition to be approved, to remove the conditions and get the permanent green card. Now, again, there are no differences between your rights, the conditional green card and the permanent green card in terms of your rights and privileges as a permanent resident in the United States. It's just that you have to go through one more process at the very end to confirm that your jobs were created, that 10 jobs per investor. And if you're with a regional center like us, that's our responsibility to show that evidence at that time. But that's just that one extra step. We just know today that your conditional green card is extended while you're waiting.
Okay. Here we go. The sustainment period definition. This was an agenda topic and a headline item that was listed by USCIS for the call, and one of the very few topics that the entire call was limited to discussing. So we were all looking forward to having this discussion on, really, how long does an EB-5 investor need to be invested in their project to maintain eligibility to get the conditions removed at the I-829 phase? Simply put, how long do I need to keep my EB-5 investment? And unfortunately, what did we get, guys?
So it was a little bit unfortunate knowing that this was an item on the agenda as of a month ago that was not discussed in the initial half hour. When questions were asked about pre-RA sustainment period, the officers and management and IPO had the opportunity to say, all right, well, let's talk about what's different with post RIA. And they didn't deliver on that. And when you don't have the opportunity to have a meaningful dialogue, we as a group just watched with the inability to have the dialogue to say, all right, well, you've established what we already know. Why don't you explain what you said you were going to explain to all of us today? And so without that, I think it left a lot of people lacking. It's a common question that comes up with my investors who want to know what the RIA really means. And we can interpret it, but we are not IPO. We are not USCIS. We can guess, but until then, we're using status quo as the path forward. They restated what status quo was today and just answered questions that were not directly germane to what we thought we were going to hear.
Yeah, I mean, it was frustrating. I thought there would be a lot more conversation about it. And ultimately, I wonder if they pick and choose which Q&A questions they were selecting because they ignored all of those as well. Yeah, we didn't get any sort of feedback at all. And to think that everybody on that call, nobody was asking questions about sustainment period. I know I was typing on there, so they definitely ignored my questions. So
and they left time on the board. They ended 10 minutes early. You know, we get to talk to these people once in a while, hopefully on schedule, not this time. And they cut off 10 minutes at the end.
Yeah, one of the actual responses that they gave when someone had pointed, like, is there any upward limit to how long the EB-5 invested capital could be invested? And that potentially was coming from an investor that may have been told that, you know, there is none and that their capital is stuck and there's no return. They had asked for USCIS's help to figure that out. And USCIS just blatantly, point blank, told him there is no upward limit as for the INA for how long their invested capital could be invested. There's no mandatory return period. And it's probably something that's managed in the commercial language of the investment documents that they entered into at the time of the investment, rather than something that USCIS would dictate. So USCIS kind of deflected on that one.
And I think that's important for us and our investors. Yeah, go ahead, Peter. You're going to say what I'm about to say.
Well, I was just going to say that USCIS doesn't have a time limit on the investment because, frankly, you know, the statute is concerned about a minimum time frame of investment, and really the USCIS is concerned primarily with job creation more so than the actual performance of your investment. They're more concerned that to show evidence that your investment led to the, you know, financed this project and led to the creation of U.S. jobs, rather than, they're not as concerned about whether or not your investment is a great investment and you get a return on your investment, meaning like a profits and such. They're not as concerned on that side, and so that's why this person can't rely on the USCIS to make limits on that. You have to get those questions answered, and as part of your due diligence when talking to a regional center, and understand the documents and understand the investment and the advantages, the risks, and choose a solid platform, a solid team, that because it's a long-term commitment, and you really need to, like, as I usually tell people, you're choosing the people behind the project, not just the project itself, because you have a long-term partnership with that team.
Yep.
Exactly.
Yeah, and that's probably a discussion too for an entirely different time, just about, like the number of checkbox items that investors should go through when looking at their project and looking at what those investment periods really are going to be. Did the sponsor tie it to something that could trigger some sort of elongated delay? Is there something else driving your timeline besides items that permit to you? We've heard horror stories where there are groups out there that will tie somebody's investment period to the 5th person to enter the United States on their US green card. And that means if everybody before them was retrogressed and in backlogs, and then you're waiting for not only the I-526, but the 485 and to get issued the conditional or the visas and the conditional green card, and 5 of them would then trigger a 5-year investment period. That's obviously not 5 years. So there can be people out there that are using kind of tricky language, changing the real timelines on this stuff. And, that poor person on the call was looking for USCIS to give them something definitive, and it just wasn't there. So definitely reading the documents and talking it through specifically with your sponsor team is really important. So on this slide, the other item that is discussed is, an individual, I guess, had read a lot of RIA language about terminations and trying to protect innocent investors and collateral damage. And, they had asked if they were going to be notified, what was notified if your regional center was terminated. What did you guys kind of hear when you were reading between the tea leaves on that?
Well, I think, they gave, as USCIS usually does on these calls, they gave the shortest answer possible within the plain language of the statute. And so, but the good thing is that under the RIA, there is language in the statute that says if a regional center is terminated, then that investor will have the opportunity within a 180-day period to switch regional centers, or to have the NCE be sponsored by an alternative regional center. So and so there is that safety mechanism. Practically speaking, logistically, I think there's going to be a lot of difficulty in that, in terms of how do you identify these regional centers. Will a regional center take on a terminated RC's NCE, and what kind of negotiations, risks, assumption, and so forth is involved in that. But that's there. That is there now. In addition to grandfathering, just kind of tangential here, that there is a grandfathering provision in the RIA for investors if the program itself is terminated or suspended. That USCIS can no longer do what it did last year and just stop working on regional center applications. So that it's not a basis for denial, and it's your applications will continue to be approved, even if the program disappears after 2027.
Yeah, and then hey, Greg, with your experience there at IPO, and actually being the terminator of petitions in your time, how long would it take, or like what does that process maybe look like for USCIS to find repeat offenders of the RIA and finally issue some sort of notice to terminate? Like, how long would that take?
Yeah, I mean, it becomes difficult because there's going to be different generations of actors. Some are more obvious than others. So you start with the low-hanging fruit and you go from there. You're going to have to go through a process that is yet to be publicized, right? They're trying to figure out how to do that and how to go through that process, where to start, who's in charge of it, what information you need, what type of law enforcement partners you may need to call in for assistance to substantiate what you're doing. If you need to go overseas because you're looking at agents, if you're looking at disclosures that are misrepresentative and now the SEC is involved, it is just a very complex world, as we all know. So to be in the regulatory arm of it, you need a lot of help, you need a lot of resources, and you need a lot of time.
Yeah, so it's an item that probably remains to be seen. We'll move on to the next couple topics here. Another item that seemed to get dodged that was in fact on the agenda, and it was one of the limited topics that we were supposed to be able to ask about and talk about. The previously approved RCs that are looking to wind down and exit the industry. They are no longer interested in new projects. They're going to do no activities under the RIA. They wanted a way out and a way not to pay fees. So these are guys that want out and they don't want to host any more investors. We did not get to see any kind of real definitive items on that except for money. So what did we learn about what USCIS wants from these guys? And what was the conclusions there?
I think my conclusion that's unspoken is that there's going to be a problem because there's inconsistent application of the RIA that's very clear down to the letter of the law. So for instance, USCIS data shows there's still over 600 approved regional centers. We expect many of those to fall off And if the filing deadline was held to be December 29th, people in regional center principals would have already had to decide whether or not to stay on board or not. But the industry pushed back to try to figure out whether or not a previously approved regional center could continue to have their operations go without re-registering for post RIA. And to this day, this has not been figured out one way or the other. And as we saw in this phone call with the direct question, this was punted again. They still need more time to figure this out. Yet they're going to charge everybody an integrity fund fee, or they're going to be terminated. So now they're almost using a duress play financially to force people to make a decision, either to self-withdraw or face termination, which is just by nature very strange for a government entity to do, that's asking us to police our own to such an extent. And now they're using finances to kind of push us into a decision. The industry is not going to respond well to this. And as soon as there's a notice of intent to terminate to a regional center who has not paid because they're pending clarification that's important to their existence, you've got a lawsuit on your hands. And this is also part of the Behring settlement to some extent. This is going to get ugly pretty quickly. And today's answer was not clear enough, or there was not an opportunity for follow-up questions that could have assisted us to learn how to move forward. Policy manual still has nothing for us here.
Yep. Greg, we got a question for you, specifically, coming from, Keyshore, and the people on the call may not have been part of a USCIS engagement before. The big question is the way they answered these questions, the amount of content we got. Was this a typical engagement call? And is this typical of USCIS? Like, what should we have expected?
There's a lot of people working hard to figure out a solution to a very difficult problem that they didn't necessarily create, but they're in charge of interpreting a new policy that came down on them from Congress. And as we've seen, 14 months have gone by with several holes in implementation. It's got to be frustrating. And as somebody who used to work there, I can relate to their experience, especially as I was part of the 956 rollout team. Things change fast, and it becomes very difficult to be able to find that you have a good footing to move forward. And for one reason or another, that doesn't solve problems, and it creates more gaps, and it can create more problems. If you're unable to manage your own ship the way Congress wants you to, and everybody's mad at you, and then now USCIS is letting you talk to the public like once a quarter for, they say, financial reasons, I don't think that's efficient. It doesn't promote the efficiency of the service. And I think to some extent that's got to be a morale issue. And I think for me, if I was in that position, I would have a hard time with that, trying to do my best to help a program that I believe in to create jobs without having the tools that the private market would have available, which is just communication opportunities. We need more communication opportunities. So what do I expect? I don't know. It really just depends on the question. I thought Nadine did a wonderful job. She's formulaic. She's very smart. I used to work on her team. I think that she handled herself very well. She was very thorough. She handled some redundant questions without feeling frustrated. She wasn't terse with the product users. She was there to deliver a message and try to deliver information. So it can depend on the question. These are real people. So, be aware of that. If somebody gives you a terse answer, it really doesn't mean that they don't like you. It means that they just not have the goods, and maybe they wish they had better answers.
Yeah. And I don't know if you were ever a part of it or any sort of the game planning for these kind of calls or in the room, but, is there a playbook that's handed down to these teams where it's like, you need to avoid certain topics, or like you respond with X, how governed are they?
I think we saw that today with some of the questions that were presented and the answers that were received.
Yep. Understood. Okay.
And they have to be by their very nature. I mean, they cited the statutes, including the RIA, that limits, what they can say or how they can interact with stakeholders. And as we've seen, even though it was a last resort for us, I mean, it can be a litigious space. And so they, and some of these issues, have ambiguity in them inherently because of the way that Congress wrote the statute. And that's a systemic problem with Congress, where they deliberately write in vague ways to kind of punt the issue and let the agency try to figure it out, and or the courts figure it out. And it's not the best way of governing, but that's kind of where we are.
Reality. Yeah, and I guess that's the difference between, call it like statute and policy versus the adjudicator's manual. It's passed down.
I was just about to
the real rules.
Mention that. I was going to mention that earlier, that and this is for many of our viewers who are existing or potential EB-5 applicants, and the frustration I think I understand from them is that there's just not a great official database or information repository that they can go to and just kind of rely on updated information, transparent information. And the best you have is USCIS.gov website, right, on the EB-5 side, where they have approved regional centers, where they have news about our lawsuit about Behring Regional Center, and the manual, the policy manual. And we learned today, and which we all know, but maybe some of our viewers aren't aware. We learned today that they still haven't updated all of that manual, and that's the closest that investors have as an official document that they can access on the rules and regulations regarding like a more detailed explanation of EB-5 rules. And USCIS, a year later, after the implementation of the Reform and Integrity Act, it still hasn't finished updating the policy manual. So if people see things out there that might be confusing or seem outdated or seem different from maybe what we even say or speak about on our website, blog, or on our YouTube channel, or even on the phone, there might be actually a disconnect or just a delayed update by USCIS. Yeah. And so it's just good to get your questions answered, not just by us, but also by your attorneys, your immigration attorneys, because it's obviously their responsibility too to represent you and interpret the law so that you present the best case forward. So that's what this is all about, really. It's just getting information.
And I think that's a good thing to bring up, is like the time lag in USCIS kind of reaching deep into their archives, cleansing the website of old content, relevant content, things that are just even gross error at this point. You can find blogs and or written pages on the USCIS.gov website right now that are still indicating 1.8 million as the minimum investment. There's things in there where you run simple searches for really simple answers, and there's just a lot of pages. And these conversations, the answers from USCIS on updating these items was simply that, there's a lot of web pages and we'll get to them. There's not like a hard line where the law is written and understood through their website either. So there is this kind of delay and a lag effect of certain information getting handed down, whether it's from Congress, from statute, all the way down to the policy manual, and then further out into the public via a website or something of that nature. The other complication with this is that, the way I like to compare it or discuss it with people is that the USCIS statements are very, very much prepared. They're very much canned responses on purpose, because if you get too animated, too much personal thought, too much analogy or idioms or anything where you're just kind of more colorful in your responses, if it's misinterpreted to be in conflict with statute or law, all of a sudden the Department of Homeland Security might find themselves in litigation. It conflicts with the way a policy was previously adjudicated, an RFE or a NOID or any sort of termination. All of a sudden, if they appear to be flip-flopping on something, you have the whole industry just jump on their back and start complaining, start, writing articles and all kinds of other stuff, complaining to Congress, it's almost risky for them to say too much. So that's why we see these limited responses that are very, very much prepared. And in some cases, we'd rather they've just said nothing, which is kind of like, when are we going to get processing statistics? We'll talk about that in a moment. But go ahead, Greg.
I want to, dovetail on that. You've got people writing language at the regulatory and policy and legal level that have different experience and perspectives. People in Congress don't use the product. People that are writing the regs are not necessarily the people who are adjudicating. And then people who are writing policy about adjudications might have an experience with fraud detection and national security. And you might have different writers working on different language in the same element of one publication, whether it's the adjudicator's field manual or the policy manual or things that are for public use, things that are internal use. We are far away from Chat GPT level in terms of what IPO is able to tell us about its program, but they are trying. It's hard. It's a very human issue at the moment.
Yeah. So just as far as like spending the resources, we talked about this, like they now have a much bigger job. USCIS has invited thousands of filings potentially for 956s. Every promoter, every agent, every finder, any employee of those finders, they're collecting a lot of data here, and they're going to be able to connect a lot of dots. So, we kind of already talked about this one, but then like the very good question was asked about filing statistics. So, this was asking like, when are we going to know how many I-526Es are there? Rural, high unemployment area, infrastructure, or otherwise? When can we start triangulating to what is a potential backlog for what country, retrogression, when is the priority processing going to go up in smoke? And that's what people want to know, because priority processing is tied to retrogression. If too many people sign up, priority processing disappears. And if it's already disappeared and we just don't know it yet, why don't you just tell us how many people have filed, and like we'll make our own assumptions. And essentially, when Kevin decided to step up and answer this question, he was just like, no, you will get no statistics. You will see the visa bulletin when it's current, and when it's not, that's all you get. So they're not going to give us the I-526E petitions, which is what the question wanted. He immediately steered toward the visa bulletin, which we know lags years behind actual adjudication or actual filings. So this is something that needs to be worked on. In terms of he had mentioned really just the visa bulletin, and Peter has a whole playlist on how the visa bulletin works, how it's calculated. Greg, you and Peter sat with Charlie Oppenheim and had a real long, deep discussion exactly how the Department of State goes through this stuff, how they actually calculate visa numbers, how retrogression falls out, and how it should be expected to play out in the future. But what did we learn from this call? Anything new?
My takeaway was that Muck didn't feel like it was his place to say. He kicked it over to the State Department, but State Department would kick it back to USCIS saying we need adjudication data in order to determine the dates on the visa bulletin. And we all know that. And so our investors know that. And I think that question, again, without the opportunity to ask a follow-up question, you lack meaningful engagement when you don't have the opportunity to follow up.
Yeah, sounds like it. We're nearing the top of the hour here. Is there any open questions from the group and the 25 odd people that wanted to hang around all the way through the entire hour? If you guys have any questions now, we're happy to answer them. Or people are able to see us on YouTube, see the replays, see the open content, and you're also able to make appointments for direct consultations with anyone on the team. We are obviously approachable and easily to access. So we look forward to working with everybody in the future here as time goes on. We did have a question here. Peter, I know we're going to lose you at 2 o'clock, but Greg, if you have a moment, I'm sure everybody would love to hear from you. Any ideas about retrogression? You know,
yeah, I mean, that's what that question was designed to ask. Peter, quick thoughts before you go?
Well, I would encourage people to look at our video with Charlie Oppenheim on our YouTube channel, because we did a pretty deep dive on this issue, especially with respect to the reserved visa set-asides. So the reserved visa set-asides are the newly established visa lines within the EB-5 category, right? So there's an annual limit, worldwide limit of approximately 10,000 visas per year. We've had some benefit of carryover of unused family-based visas, and EB-5 gets a portion of that these past couple of years, but some of those were wasted, frankly, because of just slow processing times. The reserve visas, we actually expressly by statute do get carried over. So the new reserve visas from last year were carried over to this year. And we'll probably see a carryover to next year as well for several of those visas. So I think retrogression's in the future, because there's just a natural limit to these visas. But potentially we'll see some final action dates maybe at the end of 2024, maybe 2025, just depending on how many of these visas get rolled over.
So you're talking about 15, 18 months just to get any sort of retrogression in place. That's the question then. So the simple answer,
nothing imminent, but it does behoove people to get an earlier priority date, because without more public information from USCIS, it's just kind of hard to gauge.
Right. Yeah, because in order to get retrogression, you have to count backward. So too many visas need to have been filed, and then too many visas need to have been approved to where the quota disappears for that certain country. Each country is limited to about 7% of the total 10,000 visa allocation. Then once that actually happens, then you get the visa bulletin rolling back the dates on priority dates. So you have to have all the filings, all the approvals, and then the visas being issued by Department of State to actually hit the limits. That's why it takes so much time to get to retrogression. And then by the time retrogression is actually issued, you probably had that 15 or 18 months or so of more people filing. So, you're going to have this whole group that is kind of driving into the fog, not knowing that they're already retrogressed. And that's where we come in, trying to draw the math, trying to track I-526 filings and filing statistics from USCIS and then count through it. So it's really important to pay attention, keep up with the videos and all of our visa bulletin updates, also I-526 processing statistics, filing statistics. We are constantly surveying all the immigration attorneys, other friendly projects. We're all trying to find out what the real answers are. And unfortunately, we can only triangulate using different data points in order to make that work. Until USCIS wants to release the proper data at the proper times with the proper benchmarks attached to them, there's no perfect way to get to it. So looking at other questions, Peter, I know, did we lose you at 2 o'clock? I don't know if you've got a jump.
Okay, for a few more minutes.
Okay. So that was the idea about retrogression. Another question's here, talking about, looks like some Oakland stuff and other Bay Area. Many startups in the area switching to remote work and permanently, then ideas about office vacancies and all those kind of things. As far as like the general market, we are seeing an oscillation. We are seeing the pendulum swings, and we are seeing a lot of movement. So in the beginning of COVID, people talked about paradigm shifts. People talked about the idea of work from home. Some things were going to be permanent. Others thought it would be permanent. And then even people were celebrating the idea of how effective it was. And this was an example from Mark Benioff of Salesforce, where he talked about how incredibly efficient their team was working through COVID with the idea of remote work and work from home. And then all of a sudden, the mandate completely switched, where all of a sudden they need to be 3 days in the office. Certain managing directors are going to be 5 days in the office. And the rhetoric changed entirely, saying, we just are a lot more productive in mentoring, training, coaching, and growing if we are together. So there are certain groups that are going to hang on to remote work. There are certain groups that are going to be returned to office. It's absolutely the right answer to expect that it's going to be hybrid to a certain extent, but it was also, significantly hybrid even before the pandemic. People were traveling a lot. Office occupancy before the pandemic was even, 60 to 80% for when we thought we were full-time office people. That's just because, on any given day, the offices really were only 2/3 full between people traveling or people that are on their own schedules and salespeople that are out of the office. The world was already hybrid on a traditional basis even before the pandemic. As far as offices, you're seeing a rotation of tenants. Right now, there is a significant vacancy and a record vacancy for San Francisco and some of the places in the Bay Area, even recording as high as from 18% all the way to almost 30% in some submarkets. That's because you're getting that rotation. People are consolidating office footprint. New players are coming in. $6 billion was raised in the first quarter of 2023 for AI alone in the San Francisco Bay Area. As you see some groups that are tiring out and they are giving up office space and or moving to cheaper locations because their business models don't support the expense, those people are moving out. Major value creating industries are moving in. And then very, very interesting statistics that came out of demographics posted in the most recent CBRE reports talking about the influx of people into the Bay Area. You are seeing wealthier, more educated, and more high value jobs moving in versus the ones that relocate out. And whether or not these were individuals that were outside the Bay Area to begin with and or they left and came back, you are seeing the entire demographic rotate more wealthy and higher earning than ever before. So as far as the commercial office side, you have a huge problem for old defunct offices that can't attract a new tenant to want a long-term lease. You are going to see those get rehabbed. Those are going to get stripped to the bones and completely redeveloped, not torn down, but they're going to get redeveloped. For new Class A office, if you actually look at rents and asking rents, Manhattan right now is setting records for some office leases for trophy quality buildings and prime locations that people know they want for long-term future use. So there's definitely a flight to quality when it comes to the office and the commercial component right now in real estate. Residential rents, city by city, everything is totally different for apartments and multifamily. New York had 30% year over year growth. San Francisco Bay Area was more muted at anywhere from 1% to 4% growth, depending on the submarkets. It all return to office has driven a lot of it. So complicated question, needs deep data and updated data to really parse it out. And as far as there's a question in there talking about Google abandoning a San Jose campus. Google owns nearly 200 different properties in San Jose, Mountain View, and the rest of South Bay. If they've abandoned anything, it's a sliver of their portfolio. That changes things a lot. Also, some of the much larger groups are looking for distributed workforce, trying to take advantage of other geographic locations. Others are not. So we probably need an entirely different video for all this stuff. But we did have one that we published earlier in the year that was talking about the end of 2022 statistics. That is on the YouTube channel, and I would check that out if you want some general demographic work and looking at macroeconomic as well as some local microeconomic indicators for the Bay Area in general. So any other questions regarding either market related and or immigration related? You've got the experts here, so this is your chance to talk to them. Otherwise, we are able to close out, and we will wait until the next event, hopefully, which won't be too far away. So if there are no other questions,
Well, we
Greg,
do have, speaking of next events, as part of our settlement agreement with USCIS in our last lawsuit victory, we do have quarterly talks with USCIS directly over the implementation of the settlement of our lawsuit. And I think the next update, the next meeting is May 1st, I believe.
Yeah.
And so there will be, and USCIS actually will publish the minutes and notes from that conversation on its website. It takes a couple weeks, but we'll update folks when we can.
Yeah. Okay. So again, thank you guys for sharing your knowledge and your experience. Everybody enjoyed it, and the industry needs more people to have plentiful discussion about all this content and how to parse through it as well. So we're all very thankful for you guys contributing. If there are no more questions that come through, we will close out. Until next time, you're able to book appointments there in the corner if you want to talk to us personally. Otherwise, email, phone numbers, and our chat desk, 100 ways to get a hold of us. So thank you, everyone. And until next time, thanks again.
Thank you.